This conference will now be recorded.
Is it recording?
All set? Okay, good morning. This is the Town of Ocean Ridge Special Magistrate Code Enforcement hearing for March 2nd. It is 10 o'clock. My name is Damity Barnard. I'll be the Special Magistrate presiding over this morning's hearing. I do not believe we have any respondents present, but the first thing I'm going to do is swear everybody in who's going to testify. If you could raise your right hand, anybody who's going to be speaking. We don't have anybody on the telephone, correct? Okay. Do you all swear from the tell the truth, the whole truth, and nothing but the truth? Thank you. Briefly, a bit about the process. The town's going to go first. The cases are typically called in the order that they appear. Town will go first, present its evidence, and then the respondents, if they appear between now and when their case is heard, will then get to offer up any evidence or testimony that they have. Since there are no respondents, I'll go ahead and have the town proceed. I did review the January 5th, 2021 minutes, and I hereby adopt those minutes. And with that, Tom, you may proceed.
Thank you, Your Honor. Good morning.
Good morning.
First case we're bringing back is violation hearing case number 2020-005. Can you hear me okay?
Yes, sir.
Okay. And the title of the case is The Tamarind, Inc. The address is 6665 North Ocean Boulevard, Ocean Ridge, Florida, 33435. And this was initial violation of section 22-1 of the town code. And that's failure to maintain fire equipment according to the town code. The respondents have been working in good faith with the town, and we are going to continue this. The proposal is to continue this for 30 days, then to come into compliance. And we will bring this back at the April, I believe it's the 6th.
Mm-hmm. And has the town communicated with, I believe there were attorneys at some point involved, or is the respondent in agreement with the continuance?
Yes.
Okay. Okay, in case 2020-005, I will grant the agreed upon continuance to April 6th, 2021 at 10 a.m.
Are you going to reserve the cost, the administration cost?
Yeah, I don't know that we need to, let me check the previous order. I don't think I've been doing that in each continuance. Yeah, we'll do it at the violation hearing if we get to that point.
Great. The next case is violation, case number 2020-022. That's Andrew and Jennifer Berkman. The address is 35 Spanish River Drive, Ocean Ridge, Florida, 33435. And nature of the violation was violations of section 67-51 of the town code and section 105.1 of the Florida Building Code 6th edition, section 105.1 by performing without a permit, and section 1804.5 adding fill in special flood hazard area. As an update, we have reached a settlement, a tentative settlement agreement that has been executed by the respondents, and we are bringing that agreement back for your approval. Have you been provided a copy of that agreement?
I do not believe so, no.
And we are recommending approval of same.
And this case was continued from the previous hearing, is that right?
Correct.
Yes.
Okay, and I'm going to read this settlement agreement, but just briefly, can you give me the nuts and bolts?
Sure. So we went back and we looked at the specific provisions cited in the violations and felt that based on the town code, and questions involving the amount of fill and prior work, that those violations were not easily provable. So we are moving forward. There was a concession by the respondent to undertake certain action with respect to trees that are located in the right of way. And pursuant to the terms of this agreement, they're going to cut those trees down to a height of 3 feet. And the town will thereafter remove those obstructions entirely.
Okay.
Both parties have agreed to pay for their own attorney's fees, and all matters are resolved as to these specific violations.
Okay, and that includes any administrative fees for the town in
Correct.
prosecuting any of the previous hearings, correct?
Correct.
Okay, it looks like the settlement agreement has been signed by the respondent. And it has not yet been signed by the town, but I presume since it's here before me that the town agrees to this.
Yes.
Okay, so in essence, I think the only thing you need from me is just an order acknowledging the settlement agreement.
Correct.
And I'm happy to grant you that order. So in
Thank
case 2020-022, I will enter an order acknowledging the settlement agreement that has been prepared and agreed to by both the town and the respondents in this case. Okay. thank you,
Okay,
sir.
next case, Your Honor, is case number 2021-001. It's a new case. The respondent's name are Jerry and Sandra McMahon, and the address is 77 Island Drive South, Ocean Ridge, Florida, 33435. Nature of the violation is violation of section 68-81 and 67-174, failure to maintain and repair seawall for maintenance and appearance standards according to the town code. And this is another matter that we are going to give the respondents until March 30th to comply. And if not, we intend to bring it back at the April 6th hearing. But this was originally posted, and there has been discussions with the property owner.
Okay, is there a case file? I'm not seeing a file for this one.
I've got it.
Thank you, sir.
You're welcome.
So the town is seeking a finding of violation today, is that correct? This is.
No, Your Honor, we're going to give them, we just wanted to bring it to your attention because it was originally posted.
Okay, so essentially you're asking for a continuance?
Okay with that, or do you want to establish
If, I'm fine going either way, but if we're gonna, if you're asking for a finding of violation, I need a testimony of the building
Yes.
official, we need to get into the merits of.
Well, we can give them, that's a great question. Thank you, Your Honor. Let's go ahead and get testimony from the building official. And we can give them until the 30th to comply. And if not, we'll bring it back on the 6th to impose.
Okay, go ahead, sir.
Good morning, Your Honor.
Good morning.
So on December the 8th of last year, myself and the town engineer, Lisa Tripetti, were called to take a look at the seawall structure. What we recognized were that there were significant cracks and rusts and washouts. And our requirement was for the property owners to first have an engineer to evaluate the structure and have it certified. The rest, the superficial covering and the covering of the holes and such, would happen after the certification by the engineer, assuming there were no required repairs. The owner has gone to the end of the list and has covered up the area, painted over the cracks and the rusts, and is asking us to drop the request for a engineer certification. We do believe that this is extremely necessary. It is a seawall structure that actually is on the opposite side of this property across from a public street. So failure of this wall would create significant damage to the road structure. It is a requirement that we do believe is necessary. Myself and the town engineer do believe this is vital, and this is the one portion, I think, which was the most significant that the homeowner has yet.
Thank you, sir. Let me just look through the pictures quickly. So in this case, what would be deemed compliance on the part of the respondent? Is it not only getting the engineer's certificate and getting an evaluation, but also whatever repair is deemed necessary by that engineering assessment? Is that correct?
Correct, Your Honor. If that engineer requires certain repairs, those repairs will have to be effective. If the engineer certifies that the wall is structurally sound, the town will accept.
And have they done everything? You mentioned that they had done some amount of kind of correcting the appearance and backfilling the gaps. Is that fully complete as of this moment, or is there still backfilling and filling in of holes to be done?
Well, they have backfilled and painted, and even with the new paint, the rust is still protruding through the paint, which enforces our evaluation that something else is going on. With regards to the fill that's there right now, if there are structural cracks, in a few weeks, those holes will reappear. So, we do need the engineer's evaluation of this structure.
And I see in your letter from December 11th that the final step, which we haven't discussed, is if the engineer does determine it to be not structurally sound, they need to apply for and obtain a permit from the town to do whatever repair or replacement is necessary.
Yes, that is required. That is required. Whatever is necessary to remediate the wall, all the necessary permitting if required. Have to be adhered to.
And were we expecting the respondents to be here today?
Not that I'm aware of, Your Honor. Oh, that was the email that came through?
The respondent contacted me yesterday and said he was in Ohio, and his daughter sent an email to the town, and which I've put in the
Okay.
file.
Okay, is the town okay with entering this in as part of the composite exhibit?
Yes, Your Honor.
And in essence, just so the record is clear, it's a correspondence between the respondent and the town, providing for what remedies the respondent has made to the property to date, and at the end requesting essentially a 30-day continuance in this case, while they continue to try to comply, with essentially how it reads. So in case, before we go any further, in case 2021-001, I do find that notice is good and sufficient, and I will enter into the record, the town's composite exhibits. Without objection, let the record show that the respondent is not present here this morning. And I guess we'll label this as Exhibit 11, the communications from the respondent. So I'll hereby enter that into the record. So the town has asked for compliance by March 30th, or appearance in essence at the 4/6, what would be a fine assessment hearing.
Correct, Your Honor.
Is the town amenable to having that be a status/fine assessment
Yes,
hearing? Just I'm a little
definitely.
concerned that.
Depending on what comes back in that.
Yeah, assuming that the respondent continues to make diligent progress.
Yes.
I just want to allow, especially since permitting now seems to be involved or could potentially be involved.
Yes, that's acceptable to the town.
And what, in the event of non-compliance, what fine amount is the town seeking?
This was the first, so it would be 250 a day plus administrative.
And I have a cost recovery sheet. It appears the administrative costs are $184.40 for this morning's hearing. Let me just confirm. Yes. Okay. Anything further from the town?
No, Your Honor.
Okay, in case 2021-001, as I said, find that notice is good and sufficient for this morning's hearing. I find that the respondents, based on the testimony of the building official, are in the photographs and evidence presented in the case file, that the respondents are in violation of section 64-81 and 67-174 of the town code for failure to maintain and repair seawall for maintenance and appearance standards according to the town code. I hereby require that respondents comply with these sections of the code by obtaining, as is referenced in the documentation, that engineer's assessment and proceeding with obtaining a permit if necessary, if required by the engineering report, and that stuff be accomplished by March 30th, or appearance at the April 6th status/fine assessment hearing. In the event of non-compliance, I will assess a fine in the amount of $250 per day, and I will grant the town its administrative costs in the amount of 0.40 for today's administrative costs to prosecute this morning's hearing. Thank you, sir.
Thank you. Last case, this was published, and the respondents have affected compliance, just as a status. And that is case number 2021-004, 5505 North Ocean Boulevard, unit number 103, Cambridge, Ocean Ridge, Florida, 33435. The nature of the violation was violate sections of 67-51, 67-60 of the town code, and section 105.1 of the Florida Building Code, 6th edition, performing construction work without a permit according to town code. That has since been rectified, and they have come into compliance.
Okay, so this is 2021-004?
Yes.
Okay, so that's essentially being pulled from the agenda.
Correct.
And 2021-002? Is that still being heard? Number E or letter E?
Yeah, isn't that the one you just read into the record, Your Honor?
No, that was 001.
Oh, McMahon? Yeah, okay. So violation hearing, case number 2021-002, and that's Spitty Trust and Daniel J. Baruch Trust. The address is 6080 Old Ocean Boulevard, Ocean Ridge, Florida, 33435. The nature of the violation is violation section 67-51 and 67-60 of the town code and section 105.1 of the Florida Building Code, 6th edition, performing construction work without a permit according to town code. And on this, Your Honor, they were to obtain the permit, and similar to the other case, we're asking for similar treatment. They must obtain the permit by 3/30/21. And if not, we'll come back April 6th to impose fines.
Okay, and do you have a case file for this case?
Yes.
Thank you, sir.
Thank you. And with that, I'll turn it over to the building official for testimony. Whenever you're ready.
Go ahead, sir.
Your Honor, in this case, for the property at 6080 Old Ocean Boulevard, during the performance of a field observation at an adjacent property, questionable construction was noted to be proceeding at this location. A research indicated that there was an expired permit for a fence. The nature of the work, what was being done was a column was being formed with steel and associated electrical wiring. And upon investigation, there were no permits for this structure to be installed. Stop work order was placed, and the workers were advised to cease with the work that they were doing, which was unpermitted. And notice was followed up, and it was required that the permits be applied for and that the fence permit be renewed. To date, as of yesterday, we have not had an application from the property owners with respect to the work that had started on the property.
So not even an application submitted as of today?
Yes, Your Honor, we have not received any applications. We have had phone calls with the owners, and there were explanations about them hiring a contractor who was not performing and submitting the permits as required. However, there have been no physical submissions to the town as of yesterday.
Committee, yesterday, just like the previous case, the respondent came into the town hall, spoke with me, submitted correspondence that's in the file.
Okay.
They have submitted to the health department. They're waiting approval, and they do have they have a notice of commencement. And then her letter details the events leading up to now.
Okay, and the town doesn't have any objection to this correspondence being included in the case file?
None at all, Your Honor.
Thank you. Okay, I'll mark respondents, exhibit as number 9 for the case file. And in terms of fine, is the town seeking, what's the monetary amount in the event that compliance is not achieved by the required compliance date?
Same as before, it's a new case. So $250 a day and administrative fees.
Okay, I will let the record reflect that there is nobody here on behalf of this case. And I will enter into the official record the town's evidentiary case file with exhibits 1 through 9 without objection. I do find in case 2021-004 that there is good service for this morning's hearing. I also find, based on the testimony of the building official, as well as the photographs and documentation in the case file, that the respondents are in fact in violation of section 67-51, 67-60 of the town code, and section 105.1 of the Florida Building Permit, the Florida Building Code, for failure to obtain a permit for work conducted on the property. I will require that the respondents comply with these sections of the town code on or before March 30th, or appear at the April 6th fine assessment hearing. In the event of non-compliance, I will assess a fine of $250 per day, and I will grant the town its administrative cost in the amount of $184.40 for this morning's hearing. And with that, we appear to be at the end of the agenda. Anything further from the town?
Nothing further, Your Honor.
Okay, we will adjourn at 10:29.